What happens when a decedent dies owning 2 vehicles and nothing else? The answer in a moment, but before we get there, I'd like you to imagine a friend going through a what-if scenario that creeped into their lives. But luckily, they were prepared because you shared this video with them. We would appreciate it, and so will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey. We're here to educate everyone for free and hope that you drop your questions so that we can get back to you. Now, the answer to this question. If someone passes only owning 2 vehicles, what is the family to do? Typically, and in many states, there is a simplified process to transfer 1 vehicle to certain family members, usually a spouse, sometimes a child, via an affidavit of some kind, a singular document that makes it very easy to transfer that property. Often there's also a threshold on the value of what that property can be to transfer it in this way. However, if the decedent owned more than 1 vehicle, often you're still going to need to go through a probate process. If the collective of those assets that are owned by the decedent at their death, whether it's 2 vehicles, a vehicle and $1,000 bank account, what have you, you're still going to need to determine whether it's under what we call a small estate threshold. In some states, that's 50,000. In others, I think it varies. If it is under, you can do it fairly streamlined, not as simple as an affidavit for 1 vehicle, but a fairly streamlined process called a small estate. Otherwise, a full probate or administration, whether or not they had a will, is going to need to be started via a family member or the person designated under an estate plan. Hope that information is helpful. And if you have questions for us, drop them for us. We're here to help. And don't forget, please share. As always, take care.